Before I read the Part 3 pre-week notes, let me read a verse from one of the Testaments of God. Alma 7:11-12. And he shall go forth suffering pains and afflictions and temptations of every kind, and this that the word might be fulfilled which saith he will take upon him the pains and the sicknesses of his people. And he will take upon him death, that he may loose the bands of death, which binds his people. And he will take upon him their infirmities, that his bowels may be filled with mercy, according to the flesh, and that he may know according to the flesh how to succor his people according to their infirmities. Extinguishment of criminal liability. Criminal liability is totally extinguished. 1. By the death of the convict, as to the personal penalties, and as to pecuniary penalties. Liability, therefore, is extinguished only when the death of the offender occurs before final judgment. 2. By service of the sentence. 3. By amnesty, which completely extinguishes the penalty and all its effects. 4. By absolute pardon. 5. By prescription of the crime. 6. By prescription of the penalty. 7. By the marriage of the offended woman, as provided in Article 344 of the RPC. Criminal liability is partially extinguished. 1. By conditional pardon. 2. By commutation of the sentence. 3. By final discharge of probation. 4. By parole. 5. By good conduct. Payut was found guilty beyond reasonable doubt of the crime of rape committed against AAA, thus sentencing him to suffer the penalty of reclusion perpetua. He affirmed the ruling but increased the award of indemnity and ordered Payut to pay AAA moral damages in the amount of 50,000. During pendency of his appeal, Payut died at the prison hospital, as evidenced by the letter of the penal superintendent to the CA. Did the death of Payut extinguish both his criminal and civil liability? Yes. Payut's death during the pendency of his appeal before the Court of Appeals extinguished not only his criminal liability for the crime of rape committed against AAA, but also his civil liability solely arising from or based on said crime, or civil liability ex delicto. Article 89, Number 1 of the Revised Penal Code specifically provides the effect of death of the accused on his criminal as well as civil liability. According to the pertinent provision, criminal liability is totally extinguished by death of the convict, as to the personal penalties and as to the pecuniary penalties. Liability is extinguished only when the death of the offender occurs before final judgment. It is already unnecessary to rule on Payut's appeal. Said appeal was still pending and no final judgment had been rendered against him at the time of his death. People v. Payut. AAA is the second of 5 children of Amistoso and BBB. AAA was 12 years old when the rape incident happened. Amistoso had sexual intercourse against the will of AAA. Amistoso was charged with statutory rape. However, the RTC and CA convicted him of qualified rape, insisting upon his innocence. Amistoso appealed to the Supreme Court in a decision dated January 9, 2013. The Supreme Court affirmed, with modification, the judgment of conviction against Amistoso. However, the court was belatedly informed that Amistoso had died on December 11, 2012, at the New Bilibid prison due to cardiorespiratory arrest. Yet the public attorney's office, which represented Amistoso and which was apparently also unaware of its client's demise, still filed a motion for reconsideration of the court's decision on February 22, 2013. What is the effect of the death of Amistoso on his criminal and civil liability, pending resolution from court? Article 89, Paragraph 1 of the Revised Penal Code states that criminal liability is totally extinguished by the death of the convict, as to the personal penalties and as to pecuniary penalties. Liability, therefore, is extinguished only when the death of the offender occurs before final judgment. Therefore, the death of Amistoso pending appeal of his conviction extinguishes his criminal liability as well as his civil liability ex delicto. Since the criminal action is extinguished inasmuch as there is no longer a defendant to stand as the accused, the civil action instituted therein for recovery of civil liability ex delicto is ipso facto extinguished, grounded as it is on the criminal case. Undeniably, Amistoso's death on December 11, 2012 preceded the promulgation by the Supreme Court of its decision on January 9, 2013. When Amistoso died, his appeal before the Supreme Court was still pending and unresolved. The Supreme Court ruled upon Amistoso's appeal only because it was not immediately informed of his death. Amistoso's death on January 11, 2012 renders the Supreme Court's decision dated January 9, 2013, even though affirming Amistoso's conviction, irrelevant and ineffectual. Moreover, said decision has not yet become final, and the Supreme Court still has the jurisdiction to set it aside. People versus Amistoso. Prescription of crimes. One fateful night in January 1990, while 5-year-old Albert was urinating at the back of their house, he heard a strange noise coming from the kitchen of their neighbor and playmate, Ara. When he peeped inside, he saw Mina, Ara's stepmother, very angry and strangling the 5-year-old Ara to death. Albert saw Mina carry the dead body of Ara, place it inside the trunk of the car, and drive away. The dead body of Ara was never found. Mina spread the news in the neighborhood that Ara went to live with her grandparents in Ormoc City. For fear of his life, Albert did not tell anyone, even his parents and relatives, about what he witnessed. 20.5 years after the incident, and right after his graduation in criminology, Albert reported the crime to NBI authorities. The crime of homicide prescribes in 20 years. Can the state still prosecute Mina for the death of Ara despite the lapse of 20.5 years? Yes, the state can still prosecute Mina for the death of Ara despite the lapse of 20.5 years. Under Article 91 RPC, the period of prescription commences to run from the day on which the crime is discovered by the offended party, the authorities, or their agents. In the case at bar, the commission of the crime was known only to Albert, who was not the offended party, nor an authority, or an agent of an authority. It was discovered by the NBI authorities when Albert revealed to them the commission of the crime. Hence, the period of prescription of 20 years for homicide commenced to run only from the time Albert revealed the same to the NBI authorities. A killed his wife and buried her in the backyard. He immediately went into hiding in the mountains. 3 years later, the bones of A's wife were discovered by X, the gardener. Since X had a standing warrant of arrest, he hid the bones in an old clay jar and kept quiet about it. After 2 years, Z, the caretaker, found the bones and reported the matter to the police. After 15 years of hiding, A left the country, but returned 3 years later to take care of his ailing sibling. 6 years thereafter, he was charged with parricide, but he raised the defense of prescription. Under the revised penal code, when does the period of prescription of a crime commence to run? B. When is it interrupted? C. Is A's defense tenable? Explain. 2010. Answer to letter A. Under Article 91 of the RPC, the period of prescription commenced to run upon discovery of the crime by the offended party, the authorities, or their agent. B. It is interrupted by the filing of the complaint or information corresponding to the offense committed with the prosecutor. Article 91 RPC, except in cases falling under the rules on summary procedure and when filed with the punong barangay. Section 408 of the Local Government Code. Letter C. No. Parricide prescribes in 20 years. Article 90 RPC. The period of prescription started only when Z reported the matter to the police, which is equivalent to 10 years of hiding from the time of reporting to Z. The period of 3 years shall not be counted since he is absent from the Philippines. The filing of the charge 6 years thereafter is well within the prescriptive period. Guyena filed with a city prosecutor a complaint for slight physical injuries against Bautista. After conducting the preliminary investigation, the prosecutor issued a recommendation for the filing of information against Bautista. Such recommendation was approved by the city prosecutor, but the date of such approval cannot be found in the records. The information was, however, filed with the METC of Manila on June 20, 2000. Bautista sought the dismissal of the case against him on the ground of the 60-day period of prescription from the date of the commission of the crime. Has the crime prescribed? No. The crime has not prescribed. It is a settled rule that the filing of the complaint with the fiscal's office suspends the running of the prescriptive period. The office of the prosecutor miserably incurred some delay in the filing of the information but such mistake or negligence should not unduly prejudice the interest of the state and the offended party. As held in People v. Olarte, it is unjust to deprive the injured party of the right to obtain vindication on account of delays that are not under his control. All that the victim of the offense may do on his part to initiate the prosecution is to file the requisite complaint. People v. Bautista. A. While serving sentence for homicide, escaped but was rearrested and was sentenced for evasion of service of sentence. Later on, he was granted absolute pardon for homicide. He now claims that the pardon includes the evasion of service since the latter crime occurred because of homicide. Is A's contention correct? No. Pardon by the chief executive must specify the crime and does not include those not specified in the pardon. On June 30, 2004, the Office of the Ombudsman filed two informations charging Disney in the Sandigan with corruption of public officials and violation of the Anti-Graft and Corruption Practices or RA 3019 in the year of 1974 to 1986 for offering, promising, or giving gift and presents to Ferdinand Marcos. Disney filed a motion to quash the information on August 2, 2004, alleging that the criminal actions had been extinguished by prescription and that the informations did not conform to the prescribed form. Sandigan denied the motion to quash, as well as the motion for reconsideration that followed afterward. Disney commenced a special civil action for certiorari, once again alleging the prescription of the charges in the information. Is Disney's contention correct? No. The offenses charged in the information have not yet prescribed. In resolving the issue of prescription, the following must be considered, namely, 1. The period of prescription for the offense charged, 2. The time the period of prescription starts to run, and 3. The time when the prescriptive period is interrupted. The crime of corruption of public officials is punished by a penalty of prison mayor in its medium and minimum periods, and a fine not less than 3 times the value of the gift. In Article 90 of the Revised Penal Code states that the period of prescription for this species of corruption is 15 years from the date of the discovery of the crime. The prescriptive period for violation of RA number 3019, as stated in Section 2 of RA number 3326, is 10 years from the date of the commission of date of discovery by the offended party, the authorities, or their agents. Therefore, the prescriptive period for the crime which is the subject herein commenced from the date of its discovery in 1992, after the committee made an exhaustive investigation. When the complaint was filed in 1997, only 5 years have elapsed, and hence prescription has not yet set in. Disney v. Sandigan. Book 2. Crimes Against National Security. Note: crimes against national security and the law of nations are exceptions to the principle of territoriality under Article 2, Paragraph 5 of the RPC. Thus, one can be held criminally liable even if those crimes were committed outside the Philippine jurisdiction. How may treason be proved? Explain. The two ways of proving treason are: 1. By the testimony of at least 2 witnesses to the same overt act, 2-witness rule, or 2. Confession of guilt made in open court. The first mode of proving treason is by testimony of at least 2 witnesses to the same overt act. There must be 2 witnesses that must corroborate each other as to the overt act performed by the offender. Therefore, treason cannot be proven by mere circumstantial evidence. The law requires that there must be direct evidence. The second mode of proving treason is by the confession of guilt made in open court. The confession of guilt must be judicial confession of guilt made by the accused in open court. Extrajudicial confession of guilt will not suffice to bring a conviction in the crime of treason. In a time wherein the Philippines is involved in war with another country, the offender XXX Filipino citizens commandeered women of the enemy troops. Are they liable for treason? No, the act of commandeering women to the enemies does not constitute a treasonable act. This act of commandeering women to the enemies to satisfy the lust of the enemies is not a treasonable act, because whatever benefits it would give to the enemy in their prosecution of war would have been trivial, imperceptible, and unintentional. People versus Perez. Commandeering means to enlist someone to help in a task, typically against the person's will. Note, in treason, the adherence to the enemies by giving them aid or comfort must materially advance the interest of the enemy and the conduct of war. Piracy vis-a-vis mutiny. Piracy. Offenders are strangers to the vessel, hence offenders are neither passengers nor crew members. It is done with animo furandi, intent to steal, and with the intention of universal hostility. Intent to gain is an element of piracy, attacked from the outside. Mutiny. Offenders are members of the complement or the passengers of the vessel against the authority of the commander of the ship. Intent to gain is immaterial, attacked from the inside. A, B, and C hijacked a plane bound to Malaysia. In the course of the hijack, D, a passenger was shot and killed. The court charged and convicted them for the violation of anti-hijacking law and murder. Is the court correct? No. The charge should only be RA number 6235 or violation of anti-hijacking law. A, B, and C should not be charged with a separate crime of murder because the act of killing a passenger or complement in a violation of RA number 6235 will only bring about a higher penalty. Murder should not be charged separately. Crimes against the fundamental laws of the state. Crimes against the fundamental laws of the state may only be committed by public officers, except Article 133, offending the religious feelings, which may be committed by a private individual. However, not all public officers may commit such crimes. In arbitrary detention and delay in the delivery of detained persons to the proper judicial authorities, the public officers must be charged with the task of arresting or detaining a person. In violation of domicile, the public officer must have the task of serving search warrant or seizure order. What are the three ways of committing arbitrary detention? 1. By detaining or locking up a person without any legal cause or ground thereof, purposely to restrain his liberty. 2. By delaying delivery to the proper judicial authority of a person lawfully arrested without a warrant. And 3. By delaying release of a prisoner whose release has been ordered by competent authority. Is there an arbitrary detention even if the offended party were not kept in an enclosure? Yes, there is arbitrary detention even if the victims were not kept in an enclosure. The prevailing jurisprudence on kidnapping and illegal detention is that the curtailment of the victim's liberty need not be involved any physical restraint upon the victim's person. If the acts and actuations of the accused can produce such fear in the mind of the victim sufficient to paralyze the latter, to the extent that the victim is compelled to limit his own actions and movement in accordance with the wishes of the accused, then the victim is, for all intents and purposes, detained against his will. Astorga versus People. True or false? A policeman who without a judicial order enters a private house or the owner's opposition is guilty of trespass to dwelling. False. The crime committed by the policeman in this case is violation of domicile because the official duties of a policeman carry with it an authority to make searches and seizure upon judicial order. He is therefore acting under color of his official authority. Article 128. Policemen Conde, Avenido, De Gran, Rufano, and Balotlot, thinking that Galvantes was armed with a gun, pointed their firearms at him and asked for his gun. Conde went near Galvantes' jeep and conducted search without a search warrant. After a while, they saw the Super 38 pistol under the floor mat of the jeep. Galvante then filed complaints before the ombudsman. One of the criminal complaint he filed was warrantless search. Will the complaint prosper? No, the complaint for warrantless search charges no criminal offense. The conduct of a warrantless search is not a criminal act, for it is not penalized under the RPC or any other special law. What the RPC punishes are only two forms of searches, which are search warrants maliciously obtained and abuse in the service of those legally obtained under Article 129, and searching domicile without witnesses under Article 130. Galvante did not allege any of the elements of the foregoing felonies in his affidavit complaint. Rather, he accused Conde, Avenido, de Gran, Rufano, Balotlot of conducting a search on his vehicle without being armed with a valid warrant. This situation, while lamentable, is not covered by Article 129 and 130 of the RPC. The remedy of petitioner against a warrantless search conducted on his vehicle is civil in nature under Article 32 in relation to Article 2219, number 6 and 10 of the Civil Code. Galvante versus Casimiro. What are the prohibited acts consisting violation of domicile? 1. Entering any dwelling against the will of the owner thereof. 2. Searching papers or effects found therein without previous consent of such owner. And 3. Refusing to leave the premises, having surreptitiously entered said dwelling, and after being required to leave the same. While a pabasa was going on at a municipality in the province of Tarlac, Reyes and his company arrived at the place carrying bolos and crowbars and started to construct a barbed wire fence in front of the chapel. The chairman of the committee in charge of the pabasa persuaded them to refrain from said acts. A verbal altercation then ensued. The people attending the pabasa left the place hurriedly in confusion, and the pabasa was discontinued until after investigation. Reyes and his company, in their defense, claimed that the land where the chapel is built belongs to the Clemente family, of which they are partisans. Are the accused guilty of the crime under Article 133? No. Article 133 of the RPC punishes acts notoriously offensive to the feelings of the faithful. The construction of a fence, even though irritating and vexatious to those present, is not an act, as can be designated as notoriously offensive to the faithful. In this case, the accused were acquitted of violation of Article 133 of the RPC, but they were found guilty of a violation of Article 287 of the RPC, for the circumstances showed that their acts were done in such a way as to vex and annoy the parties who had gathered to celebrate the pabasa. People versus Reyes. Crimes against public order. What is the theory of absorption in rebellion? Whenever, in the course of committing rebellion, murder, homicide, arson, physical injuries, other common crimes are committed, and these common crimes are furtherance to, incident to, in connection with rebellion, they are considered as absorbed in the crime of rebellion. Only one charge of rebellion should be charged against the offender. Basis. Rebellion, Article 133, crime against public order. Purpose, overthrow the government, political crime. How committed? Through violence. Number of people, multitude of people. Offenders, private or public officers. Ability to absorb common crimes? Generally, yes. Murder, rape, robbery, absorbed. Use of loose firearms, absorbed. Conspiracy and proposal? Conspiracy and proposal, punished. Inciting, punished. Accomplices, no accomplices. These are all continuing crimes. Terrorism, RA 9372, crime against national security and law of nations. Purpose, unlawful demand against the government, need not be political. How committed? Through predicate crimes and by widespread and extraordinary panic and fear. Number of people, can be singly or a lot. Offenders, private or public officers. Ability to absorb common crimes? Yes. Absorbs predicate crimes like rebellion, coup d'etat, murder, use of loose firearms, absorbed. Conspiracy and proposal. Only conspiracy is punished. Inciting, not punished. Accomplices are punished. Coup d'etat, Article 133-A, crime against public order. Purpose, diminish inherent powers of the state, political crime. How committed? Need not be through force and violence, can be by threat, intimidation, strategy, or stealth. Number of people, can be singly or a lot. Offenders, public officers only, unless private individuals conspire. Ability to absorb common crimes, yes, but must be related. to political purpose, rape not absorbed, use of loose firearms absorbed, conspiracy and proposal punished, inciting not punished, accomplices no accomplices. As a result of the killing of SPO3, Jesus Lucilo alias Labdioro was charged with and subsequently found guilty of the crime of murder. On appeal, Labdioro claims that he should have been charged with the crime of rebellion, not murder, as being a member of the NPA. He killed Lucilo as a means to or in furtherance of subversive ends. The Solicitor General opposing appellant's claim avers that it is only when the defense had conclusively proven that the motive or intent for the killing of the policeman was for political and subversive ends will the judgment of rebellion be proper. Between the appellant and the Solicitor General, who is correct? The Solicitor General is correct. It is not enough that the overt acts of rebellion are duly proven. Both purpose and overt acts are essential components of the crime. With either of these elements wanting, the crime of rebellion legally does not exist. If no political motive is established and proved, the accused should be convicted of the common crime and not of rebellion. In cases of rebellion, motive relates to the act, and mere membership in an organization dedicated to the furtherance of rebellion would not by and of itself suffice. People versus Labdioro. Appellant with about 20 armed men and Hook Commander Torrio raided and attacked the house of Punsalan, his political adversary and incumbent mayor of Tiawang, Quezon, with automatic weapons, hand grenades, and bottles filled with gasoline. The raid resulted not only in destruction of Punsalan's house and that of others, but also in the death and injuries to a number of civilians. The CFI found appellant guilty of the complex crime of rebellion with multiple murder, among others. Was the lower court correct? No. The accused is guilty of sedition, multiple murder, and physical injuries, among others. The purpose of the raid and the act of the raiders in rising publicly and taking up arms was not exactly against the government, and for the purpose of doing the things defined in Article 134 of the Revised Penal Code under rebellion. The raiders did not even attack the Presidencia, the seat of local government. Rather, the object was to attain by means of force, intimidation, etc. One object, to wit, to inflict an act of hate or revenge upon the person or property of a public official, namely Punsalan, was then mayor of Tawang, under Article 139 of the same code. This was sufficient to constitute sedition. People versus Umali. What is the nature of sedition? Sedition is a violation of the public peace, or at least such a course of measures as evidently engenders it. Yet it does not aim at direct and open violence against the laws, or the subversion of the Constitution. It is an offense not directed primarily against individuals, but to the general public peace. It is the raising of commotions or disturbances in the state, a revolt against legitimate authority. People versus Perez. What are the elements of the second form of direct assault? 1. Offender. Makes an attack. B. Employs force. C. Makes a serious intimidation. Or D. Makes a serious resistance. Number 2. Persons assaulted is a person in authority or his agent. 3. That at the time of the assault, the person in authority or his agent is engaged in the performance of official duties, or that he is assaulted. B. On occasion of such performance. Number 4. The offender knows that the one he is assaulting is a person in authority or his agent in the exercise of his duties. And 5. There is no public uprising. Note, the force employed on an agent of a person in authority to constitute direct assault must be of serious character, whereas the force employed on a person in authority need not be serious. As the town president failed to pay their salaries, the accused, accompanied by 4 armed men, went to the house of the former and compelled him by force to leave and go to the Presidencia. The accused kept the town president there confined until the relatives of the latter had raised enough money to pay what was due the accused and the armed men as salaries. What crime did the accused commit? The facts constitute the crime of direct assault. There is no public uprising when the accused, accompanied by armed men, compelled by force the town president to go with them, to proceed to the municipal building and detained him there. By reason of detaining the town president, the accused inflicted upon a public officer an act of hate or revenge. This is one of the objects of sedition, which is essentially what the accused intended to attain. U.S. versus Piracy. A lady professor was giving an examination. She noticed B, one of the students, cheating. She called the student's attention and confiscated his examination booklet, causing embarrassment to him. The following day, while the class was going on, the student B approached A and without any warning, slapped her. B would have inflicted further injuries on A had not C, another student, come to A's rescue and prevented B from continuing attack. B turned his ire on C and punched the latter. What crime or crimes, if any, did B commit? B committed 2 counts of direct assault, one for the slapping the professor, A, who was then conducting classes and thus in the exercise of her authority, and another one for the violence on the student C, who came to the aid of the said professor. By express provisions of Article 152, teachers and professors of public and duly authorized public schools, colleges, and universities, in the actual performance of their professional duties or on the occasion of such performance, are deemed person in authority for purpose of the crime of direct assault and of resistance and disobedience. And any person who comes to the aid of the person in authority shall be deemed an agent of a person in authority. Accordingly, the attack on C is, in the eyes of law, an attack of an agent of a person in authority, not just the attack on the student. During election time, Isco was found in possession of an unlicensed firearm. Arrested, he was charged with 1. Violation of the public gun ban, and 2. Illegal possession of unlicensed firearm. During the arraignment for the violation of public gun ban, he pleaded not guilty. However, during the arraignment for illegal possession of an unlicensed firearm, he filed a motion to quash the information, arguing that he cannot be charged of illegal possession of unlicensed firearm because the law says that you can only be charged of the offense provided that no other crime is committed by the person arrested. Is his contention correct? No. His contention is wrong. When the law says provided that no other crime is committed by the person arrested, the word committed means that there is already a final determination of guilt, a final conviction of guilt based on a successful prosecution or judicial admission. In this case, he was not yet convicted, he was only being prosecuted. Therefore, both cases can proceed. However, the moment he is convicted of violation of the public gun ban, he should be acquitted of illegal possession of unlicensed firearm. Salinas and Nair versus People. Who are deemed to be person in authority and agents of persons in authority. Persons in authority are those directly vested with jurisdiction, whether as an individual or as a member of some court or government corporation, board or commission. Barrio captains and barangay chairmen are also deemed persons in authority. Agents of persons in authority are persons who by direct provision of law, or by election, or by appointment by competent authority, are charged with maintenance of public order, the protection and security of life and property, such as barrio councilman, barrio policeman, barangay leader, and any person who comes to the aid of persons in authority. In applying the provisions of Articles 148 and 151 of the RPC, teachers, professors, and persons charged with the supervision of public or duly recognized private schools, colleges, and universities, and lawyers in the actual performance of their professional duties, or on the occasion of such performance, shall be deemed persons in authority. Sideco, the cook, and the waitress in his restaurant were on the way home when they were signaled to stop by police officers who asked Sideco to open the vehicle's door and alight for a body and vehicle search. When Sideco opened the vehicle window, he insisted on a plain view search. Obviously, irked by this remark on the policeman, told him he was drunk, pointing to the 3 empty beer bottles in the trunk of the vehicle. The officers then pulled Sideco out of the vehicle and brought him to the hospital ng Maynila, where they succeeded in securing a medical certificate under the signature of one Dr. Harvey Bulacating, depicting Sideco as positive of alcoholic breath, although no alcohol breath examination was conducted. Sideco was detained and released only in the afternoon of the following day, when he was allowed to undergo actual medical examination, where the resulting medical certificate indicated that he has sustained physical injuries but negative for alcohol breath. Is Sideco's criminal liable for any crime? No. It is fairly clear that what triggered the confrontational standoff between the police officer on one hand and Sideco on the other was the latter's refusal to get off the vehicle for a body and vehicle search, juxtaposed by his insistence on a plain view search only. Sideco's twin gestures cannot plausibly be considered as resisting a lawful order. He may have sounded boorish or spoken crudely at that time, but none of this would make him a criminal. It remains to stress that he has not, when flagged down, committed a crime or performed an overt act warranting a reasonable inference of criminal activity. The two key elements of resistance and serious disobedience punished under Article 151 of the RPC are: 1. That a person in authority or his agent is engaged in the performance of official duty or gives a lawful order to the offender, and 2. That the offender resists or seriously disobeys such person or his agent. There can be no quibble that the officer and his apprehending team are persons in authority or agents of a person in authority manning a legal checkpoint, but surely Sideco's act of exercising one's right against unreasonable searches to be conducted in the middle of the night cannot, in context, be equated to disobedience, let alone resisting a lawful order in contemplation of Article 151, Sideco versus People. Manny killed his wife under exceptional circumstances and was sentenced by RTC Dagupan of Distero, during which he was not allowed to enter Dagupan City. While serving sentence, Manny went to Dagupan City to visit his mother. Later, he was arrested in Manila. Did Manny commit any crime? Yes. Manny committed a crime of evasion of service of sentence when he went to Dagupan City, which he was prohibited from entering under his sentence of Distero. A sentence imposing the penalty of Distero is evaded when the convict enters any of the places he is prohibited from entering under the sentence or come within the prohibited radius. Although Distero does not involve imprisonment, it is nonetheless a deprivation of liberty. Crime against public interest. How is forgery committed? Forgery is committed: 1. By giving to a treasury or bank note, or any instrument payable to bearer, or to order mentioned therein, the appearance of a true and genuine document, or by erasing, substituting, counterfeiting, or altering by any means the figures, letters, words, or sign contained therein. Article 163 RPC. In falsification of public documents, is it necessary that there be the idea of gain or intent to injure a third person? No. In falsification of public or official documents, it is not necessary that there be present the idea of gain or the intent to injure a third person, because in the falsification of public document, what is punished is the violation of the public faith and the destruction of the truth as therein solemnly proclaimed. Galeas versus People. Note: in falsification of private document, intent to cause damage to a third person is material. A counterfeited the signature of B, but what he entered in the statement of assets and liabilities of B are all true. Since there was no damage to the government, did he commit a crime? Yes. In falsification of a public document, it is immaterial whether or not the contents set forth therein were false. What is important is the fact that the signature of another was counterfeited. In a crime of falsification of a public document, the principal thing punished is the violation of public faith and the destruction of the truth of therein solemnly proclaimed. Thus, intent to gain or injure is immaterial. Even more so, the gain or damage is not necessary. Cobang versus People. Can falsification be committed by omission? Yes. In the case of People versus Dizon, an assistant bookkeeper, who, having bought several articles for which he signed several chits, intentionally did not record in his personal account most of the said chits, and destroyed them so that he could avoid paying the amount thereof, was held guilty of falsification by omission. Is there a complex crime of staffa through falsification of a private document? None. The fraudulent gain obtained through deceit in the staffa, in the commission of which a private document was falsified, is nothing more or less than the very damage caused by the falsification of such document. Petitioner Ursua was asked by his counsel to get a copy of the complaint from the office of the Ombudsman. Petitioner told Oscar Perez, the law firm's messenger, that he feels uncomfortable asking for a copy of the complaint since he is one of the respondents. Perez told petitioner that the latter can go there as Oscar Perez. At the office of the Ombudsman, petitioner registered in the logbook as Oscar Perez. Loida Kahulugan gave him a copy of the complaint, to which petitioner acknowledged as Oscar Perez. However, Loida learned that the person is not Oscar Perez, but in fact Cesario Ursua. Is the act of petitioner of using the name Oscar Perez a violation of Section 1 of CA number 142 anti-alias law? No. Petitioner's writing of the name Oscar Perez in an isolated transaction is not the act contemplated under Section 1 of CA number 142. The use of a fictitious name or a different name belonging to another person in a single instance without any sign or indication that the user intends to be known by his name, in addition to his real name, from that day forth does not fall within the prohibition contained in CA number 142. As amended, petitioner introduced himself in the office of the Ombudsman as Oscar Perez, which was not his own name, and he did so while merely serving the request of his lawyer to obtain a copy of the complaint in which the petitioner was a respondent. Hence, the use of Oscar Perez is not an alias name of petitioner. There is no evidence showing that he had used or was intending to use that name as his second name in addition to his real name. Ursua versus CA. Crimes against public morals. X. An 11-year-old girl has sexual intercourse with her 18-year-old boyfriend. Y. They performed the act in a secluded vacant lot. Unknown to them, there was a roving policeman at that time, hence they were arrested. What crime did they commit? The sexual intercourse with the girl constitutes statutory rape. Though the act was carried out in a public place, criminal liability for grave scandal cannot be incurred. Note: for grave scandal to apply, the highly scandalous conduct should not fall within any other article of the RPC. Thus, this article provides for a crime of last resort. Crimes committed by public officers. Define malfeasance, misfeasance, and nonfeasance. 2016 bar. Malfeasance. Performance of some act which ought not to be done. Misfeasance. Improper performance of some act which might be lawfully done. Nonfeasance. Omission of some act which ought to be performed. Governor A was given the amount of 10 million by the Department of Agriculture for the purpose of buying seedlings to be distributed to the farmers. Supposedly intending to modernize the farming industry in his province, Governor A bought farm equipment through direct purchase from XY Enterprise, owned by his compadre B, the alleged exclusive distributor of the said equipment. Upon inquiry, the Ombudsman discovered that B has a pending patent application for the said farm equipment. Moreover, the equipment purchased turned out to be overpriced. What crime or crimes, if any, were committed by Governor A? Bar 2016. Governor A committed the crimes of 1. Technical malversation, and 2. Violations of Section 3, letter E and letter G of RA 3019. Governor A committed technical malversation under Article 220 of the RPC. The amount of 10 million granted by the Department of Agriculture to Governor A, an accountable public officer, is specifically appropriated for the purpose of buying seedlings to be distributed to the farmers. Instead, Governor A applied the amount to acquire modern farm equipment through direct purchase from XY Enterprise, owned by his compadre. The law punishes the act of diverting public funds earmarked by law or ordinance for a specific public purpose to another public purpose, hence the liability for technical malversation. Governor A can also be held liable for violation of Section 3, letter E of RA 3019. All the elements are present through manifest partiality in favoring his compare. Governor A did not hold a public bidding and directly purchased the farm equipment from his compare. Further, Governor A actions caused undue injury to the government as well as the farmers who were deprived of the seedlings. His acts likewise gave his compare, a private party, the unwarranted benefit, advantage, or preference to the exclusion of other interested suppliers. The act by Governor A is also a violation of Section 3, letter G of RA 3019 for entering a contract on behalf of the government, which is manifestly and grossly disadvantageous to the same. The public prosecutor has to render his resolution on a case filed before their office. While the investigating public prosecutor was already drafting his resolution, the respondent in the said case arrived. A closed-door talk took place between the two, wherein the respondent offered the public prosecutor $2 million in exchange for the dismissal of the case filed against the respondent. The public prosecutor accepted the $2 million. Later, by reason of the bribe money given to him, the prosecutor issued a resolution dismissing the said case for lack of probable cause. What crime or crimes are committed by the public prosecutor? The public prosecutor is liable for direct bribery under Article 210. First, he is a public officer. Second, the said public prosecutor accepted a bribe money in the amount of $2 million in connection with the performance of a criminal act, which has a connection with his official function, hence he is liable for direct bribery. The public prosecutor is also liable for dereliction of duty in the prosecution of offenses under Article 208 by reason of the $2 million given to him by the respondent. The public prosecutor actually rendered the said resolution dismissing the case, despite his knowledge that the offender had actually committed a crime. He is a public officer who has the duty to prosecute, and he knows the commission of the crime. Yet he did not cause the prosecution of the offender. He did so with malice and deliberate intent to favor the violator of the law because of the bribe money given to him. So in this case, the public prosecutor is liable for two crimes: direct bribery and dereliction of duty in the prosecution of offenses. Without direct bribery, dereliction of duty in the prosecution of offenses will not be committed. Are you going to complex these crimes, considering that one is a necessary means to commit the other? No. Article 210 prohibits the complexity of crimes. Under Article 210, the liability of direct bribery shall be in addition to the liability attaching to the public officer for the commission of the crimes agreed upon. X, a police officer, was conducting a patrol in an area when he noticed a man hiding behind a mango tree. He saw that the man was intently looking at the house across the street. When the gate of the house opened, just as when a car was about to leave the house, the man immediately boarded his motorcycle, went near the said gate, and thereafter repeatedly shot the driver of the car, which resulted to the instant death of the latter. The man in the motorcycle got away. The police officer chased him and was able to arrest him. However, the man in the motorcycle said, "If you allow me to leave, I'll give you $500,000. The police officer accepted the money and allowed him to leave. What crime, if any, is committed by the said police officer? The police officer is liable for qualified bribery under Article 211-A. The police officer is a public officer in charge with the enforcement of the law, and he resisted to arrest a person who has committed a crime punishable by reclusion perpetua and/or death. The police officer did not arrest the said man because of the $500,000 given to him. X has been appointed as the new head of LTO. During his first day in office, Y visited him. Y talked to X, and after their exchange of pleasantries, the visitor left. When Y left, he also left a small gift box on top of the table of X containing a key of a new car and a note that the car is in the parking space at the basement of the building. X went to the basement and used the car. Is X liable for any crime? X is liable for indirect bribery under Article 211 because he is a public officer and he accepts a gift by reason of his office. Y, the visitor, does not require him to do anything. It was merely given to him because he was newly appointed as the LTO chief. His acceptance brings about the consummation of indirect bribery. In the above-mentioned cases, what is or the criminal liability of the person giving the bribe? They are liable for corruption of public officials under Article 212. It is committed by any person who shall have made the offers or promises or given the gifts or presents in the consummation of direct or indirect bribery. Melda, who is the private secretary of Judge Tolitz, Naya, was persuaded by a litigant Jumbo to have his case calendared as early as possible for a consideration of 500,000. May she be held criminally liable for his accommodation? The answer would depend, be qualified by the implication of the phrase to have his case calendared as early as possible. If the phrase is interpreted as an unjust act in violation of the rule to give priority to older cases, then she would be liable under direct bribery for an act which does not constitute a crime, but is unjust. He may also be held liable under Section 3, letter E of RA 3019, the Anti-Graft and Corrupt Practices Act as amended, giving any private party any unwarranted benefit. If you interpret the phrase as non-violation of the rules and regulations, then he can only be held liable for direct bribery. What will be the criminal liability of Melda if she volunteered to persuade Judge Tolitz Naya to rule in Jumbo's favor without asking any consideration? Melda is not criminally liable because the act of volunteering to persuade is not a criminal act. It is the act of persuading that is considered a criminal act. The act does not fall under Article 210 of the Revised Penal Code on direct bribery, nor does it fall under Article 211 of the RPC on indirect bribery. Neither does it fall under the Anti-Graft and Corrupt Practices, Section 3A of RA 3019, refers to acts of persuading another public official to violate rules and regulation. Don Gabito, a philanthropist, offered to fund several projects of the mayor. He opened an account in the mayor's name and regularly deposited various amounts ranging from 500,000 to 1 million. From this account, the mayor withdrew and used the money for constructing feeder roads, barangay clinics, repairing schools, and for all other municipal projects. It was subsequently discovered that Gabito was actually a wetting operator, and the amounts he deposited were proceeds from his wetting operations. What crime or crimes were committed, who are criminally liable, explain. Don Gabito is liable for corruption of public officials under Article 212 of the Revised Penal Code for having given the amounts that were deposited in an account which he opened in the mayor's name for no reason but the public position or office held by the mayor. The mayor is liable for indirect bribery for accepting such money deposited in his account by using them when he were given to him for no other reason except for his public position as a mayor, in violation of Republic Act 6713, Code of Conduct and Ethical Standard for Public Officials and Employees, and for receiving such gift from someone who may be affected by the functions of his office. Accused Hernandez served a mission order against Tokao Ayogi, a Japanese national. There were complaints against Oyagi for being suspected as a Yakuza big boss, a drug dependent, and an overstaying alien. To prove his innocence, Oyagi gave his passport to Hernandez as guarantee for his appearance at a bid hearing. In a meeting outside the bid office, accused Hernandez allegedly demanded 1 million pesos from the return of Ayogi's passport. Because of such demand, an entrapment operation was made. In a meeting to return Ayogi's passport, Hernandez immediately left after the payment was made to his co-accused. Is the act of direct bribery committed even though his act of returning the passport is not a crime? Yes. The second kind of direct bribery was committed by the accused. Accused was convicted under the second kind of direct bribery, which contained the following elements. The offender was a public officer who received the gift or presents personally or through another. 3. In consideration of an act that did not constitute a crime. And 4. The act related to the exercise of official duties. First, there is no question that the offense was committed by a public officer. Hernandez extorted money from the Oyagi spouses for the return of the passport and the promise of assistance in procuring a visa. Second, the offenders received the money as payoff, which Acejas received for the group. Third, the money was given in consideration of the return of the passport, an act that did not constitute a crime. Fourth, both confiscation, and the return of the passport were made in the exercise of official duties. Acejas III versus People. Torres was the principal of a high school. The school's collection and dispersing officer prepared 3 checks representing the teachers' and employees' salaries and other compensation for the month of January to March 1994 in the total amount of $196,654. Torres signed the 3 checks and encashed them. However, he never returned to the school to deliver the money and contends that a group of armed men took the encashed cash from him. The RTC convicted Torres of the crime of malversation of public funds. He appealed his case. May Torres be properly convicted based on the information which clearly charged him with intentional malversation and not malversation through negligence, which was the actual nature of malversation for which he was convicted by the RTC. Yes, to sustain a charge of malversation, there must either be criminal intent or criminal negligence. And while the prevailing facts of a case may not show that deceit attended the commission of the offense, it will not preclude the reception of evidence to prove the existence of negligence because both are equally punishable under Article 217 of the RPC. Even when the information charges willful malversation, conviction for malversation through negligence may still be adjudged if the evidence ultimately proves the mode of commission of the offense. The dolo or the culpa present in the offense is only a modality in the perpetration of the felony. Even if the mode charged differs from mode proved, the same offense of malversation is involved and the conviction thereof is proper. Torres versus People. Major Cantos was assigned to supervise the disbursement of funds for the PSG personnel and to perform other finance duties. He placed the money in a duffel bag and kept it inside the steel cabinet in his office. One day, he inspected the steel cabinet and discovered that the duffel bag, which contained the money, was missing. He was found liable by the RTC for malversation. Major Cantos contends that he could not be liable for malversation for mere failure to produce the funds does not necessarily mean that he misappropriated the same. Is he liable for malversation of public funds? Yes. The presumption in Article 217 of the Revised Penal Code, as amended, states that the failure of a public officer to have duly forthcoming any public funds or property which he is chargeable upon demand by any duly authorized officer is prima facie evidence that he has put such missing fund or property to personal use. The presumption is, of course, rebuttable. Accordingly, if petitioner is able to present adequate evidence that nullify any likelihood that he put the funds or property to personal use, then that presumption would be at the end and a prima facie case is effectively negated. In this case, however, petitioner failed to overcome this prima facie evidence of guilt. Cantos versus People. Elizabeth is the municipal treasurer of Masinloc, Zambales. On January 10, 1994, he received as municipal treasurer from the Department of Public Works and Highways the amount of 100,000 known as the Fund for Construction, Rehabilitation, Betterment and Improvement for the concreting of Barangay Fanic Road located at Masinloc, Zambales, a project undertaken on proposal of the barangay captain. Informed that the fund was already exhausted while the concreting of Barangay Fanix Road remained unfinished, a representative of the Commission on Audit conducted a spot audit on Elizabeth, who failed to account for the 100,000 CRBI fund. Elizabeth, who was charged with malversation of public funds, was acquitted by the Sandigan Bayan of that charge, but was nevertheless convicted in the same criminal case for illegal use of public funds. On appeal, Elizabeth argued that her conviction was erroneous, as she applied the amount of 50,000 for a public purpose without violating any law or ordinance appropriating the said amount for any specific purpose. The absence of such law or ordinance was in fact established. Is the contention of Elizabeth legally tenable? Elizabeth's contention that her conviction for illegal use of public funds, technical malversation, was erroneous is legally tenable because she was charged for malversation of public funds under Article 217 of the Revised Penal Code, but was convicted for illegal use of public funds, which is defined and punished under Article 220 of said code. A public officer charged with malversation may not be validly convicted of illegal use of public funds, technical malversation. because the latter crime is not necessarily included, nor does it necessarily include the crime of malversation. From the facts, there is no showing that there is a law or ordinance appropriating the amount to a specific public purpose. As a matter of fact, the problem categorically states that the absence of such law or ordinance was in fact established. So, procedurally and substantially, the Sandiganbayan's decision suffers from serious infirmity. COA Auditor Florence Pagirigan examined the year-end reports involving the municipal officials of Alfonso Lista Ifugao, and during the course of her investigation, she came across a disbursement voucher for 101,736 prepared for Lumawig, a former mayor of the municipality, as cash advance for the payment of freight and other cargo charges for 12 units of motorcycles supposed to be donated to the municipality. Despite the full efforts of COA, letters informing him of the unliquidated cash advance were not sent because of the address of the same cannot be obtained. Lumawig admitted having obtained the cash advance of 101,736 during his incumbency as municipal mayor of Alfonso Lista. This amount was intended for the payment of freight and insurance coverage of 12 units of motorcycles to be donated to the municipality by the city of Manila. However, instead of motorcycles, he was able to secure 2 buses and 5 patrol cars. He claimed that it never came to his mind to settle or liquidate the amount advanced since the vehicles were already turned over to the municipality. Can Lumawig be held liable for the crime of failure of accountable officer to render account? Yes, Lumawig can be held liable with the crime of failure of accountable officer to render account under Article 218. To be held liable for such crime, the following requisites must be present. 1. That the offender is a public officer, whether in the service or separate therefrom. 2. That he must be an accountable officer for public funds or property. 3. That it is required by law or regulation to render accounts to the Commission on Audit or to a provincial auditor. And 4. That he fails to do so for a period of 2 months after such accounts should be rendered. The law does not state that there must be first a demand for an officer to be held liable, therefore he is liable to such crime. People versus Lumawig.